applicants.
Yes. Mr. Ape?
My Lord, with greatest respect.
Yes, Mr. Ape, you are for who? Claimant?
Claimant applicant, sir.
Yes, I think they cannot hear. You can hear me. Yes, Mr. Ape.
Yes, my lord, I am for the claimant applicants.
Are you there? Maybe we've lost him. Yes. Yes, Mr. Afe.
Sir, my lord, sir, I am for the
Cannot hear you.
claimant applicant, sir.
Yes. Mr. Afe, can you hear me? I cannot.
My lord, sir, I am for the claimant. I'm for the claimant, sir.
Can you hear me?
Yes, my lord, I can hear you.
Yes, can you hear me now?
Yes, I can hear you, my lord.
I cannot hear you. Serious.
My lord, sir, I don't know if you can hear me now. Can my lord hear me now?
Yes, defendant counsel.
He has gone off. I'll find him.
Mr. Nwachukwu, can you hear me? You're having issues.
My lord, I think Mr. Washuku has gone offline.
Can you hear me now?
Yes, my lord, I can hear you clearly.
Yes, counsel to the defendant.
Okay. Counsel to the defendant. I don't think it's online. He has gone off.
Okay. Okay, this is a ruling of the court. The claimant applicant by an application filed on the 25th day of May 2022 seek for the following order. An order of interlocutory injunction restraining the defendants, respondents by themselves, agents, privies, and by whomsoever from swearing in anybody as a member of National Executive of Petroleum Tanker Drivers Branch of the National Union of Petroleum and National Gas Workers, NUPENG, and in particular from swearing in the third defendant respondent as the national chairman of the Petroleum Tanker Drivers Branch of NUPENG, pending the hearing and determination of this suit, and or when an election is conducted in accordance with the bylaws of the branch of NUPENG, and then the omnibus prayer. And the grounds upon which the application is brought are as follows. A, that for anybody, including the third defendant respondent, to be sworn in to any position of national executive branch of NUPENG, it must be through a process of an election conducted by the electoral committee of the branch set up for that purpose under the first dependent respondent's national executive and in accordance with the bylaws of the branch. The first and the third defendant respondents who are in breach of the provision of the bylaws of the branch do not want an election to be conducted, but rather to unpick, impose, and swear in the third defendant as the national chairman, including other members of the executive, to take over from the current executive of the branch led by the first defendant respondent at the end of June 2022. And then thirdly, the claimant applicants and other members of the branch are interested in contesting for the position of the national chairman and other executive position of the branch. But the defendant respondent want to deny them the right and opportunity to do so against the provisions of the bylaws of the branch by handpicking the third defendant and other members to form the new executive at the end of June 2022. The application is supported by a 25-paragraph affidavit deposed to by the claimant applicant, and attached with the affidavit are exhibits AA, A1, A2, A3, AA4, AA5, and AA6, respectively. Also, the claimant applicant filed a written address and urged this court to grant the prayer thought by the applicant. On the 16th day of June 2022, the claimant applicant yet filed a further affidavit in support of this application, and attached with the said further affidavit are exhibits AA7 and AA8, respectively. In responding to the claimant applicant's application, the defendant's respondents filed a 24 paragraphs counter affidavit deposed to by one Comrade Chinda W. Ejus, who is the Assistant Secretary General and Administrative Head of the Second Defendant Union. And attached with the counter affidavit are exhibits A, B, C, D, E, F, G, H, I, J, K, L, and M. Also, the defendant respondent filed a written address in support of their contestation and urged this court to refuse the application. Can you hear me? The claimant applicant, via this affidavit in support of the application, stated that every branch of NUPENG has its bylaws which regulates the activities of the branch. And in this connection, PTD branch of the union has a bylaw duly approved by NUPENG, and going by the provisions of the bylaw of PTD branch, particularly rules 6, 16, 17, and 18 of the extant bylaws of PTD branch of Nupeng, the national executive body of the branch is constituted after an election conducted by the electoral committee set up by the current national executive under the leadership of the first defendant, who conduct the election in accordance with the provision of the bylaw. That the tenure of the first defendant as the national chairman of PTD branch, together with its entire executive, is due to expire at the end of June 2022, and with about 1 month to the end of the tenure, the first defendant and its executive members have not constituted an electoral committee or fix a date for election, and also to set out rules for the conduct of the elections into various executive positions in accordance with the mandatory provisions of the bylaws of the branch, which stipulates that the first defendant and other members of the current executive shall not later than 3 months to the branch delegate conference before the tenure of the current branch executive elapses at the end of June 2022. That on the contrary, the first defendant with a few other members of the branch are held bent to ensure that election is not conducted to elect the next executives, particularly the position of the first defendant as the national chairman of the branch. The first defendant and his cohorts embarked on an unknown procedure so as to circumvent the provisions of the bylaws of the branch by collecting signatures of members who intimidate and compel them to do so, alleging that the third defendant is the only candidate for the position of the national chairman, including other positions in the coming executive, without first setting up an electoral committee to conduct the election as provided for by the bylaws of the branch. That in the meantime, as the national vice chairman, he has indicated interest in contesting the position of the national chairman and has indicated so to PTD members, the defendants inclusive, to vie for the position of the national chairman of the branch, going by his track records as an active member of the branch. The applicant further stated that other members of the branch and himself have protested to the first defendant as well as to the second defendant on the illegal procedure being adopted and embarked upon by the first defendant to bring in the new executive at the end of his tenure as national chairman. However, all protests has been to no avail, and the first defendant is bent on going ahead to illegally make the third defendant as the national chairman and fill in other executive positions without an election being conducted, thereby shutting him out and other persons interested to contest positions into the new executive. That the two branches, that is the PDT and the rig move, operate from different offices and parks as different branches of Nufeng with their separate and distinct executive as shown on the receipt or levy ticket issued by the two different bodies. The applicant in his further affidavit filed by the claimant applicant stated that the second defendant respondent by an undated notice published the conduct of the election for petroleum tanker drivers branch of New Peng, which was fixed in the said notice for 30th day of June 2022. He said the said notice was not brought in accordance with the bylaws of PTD branch of Nupeng because Nupeng can only play a supervisory and observer role, but not conduct the said election. That upon discovering that the said notice pasted was defective, the defendant by another notice dated 29 March 2022 with the same content with the undated notice fixed the election for 30th day of June 2022. That exhibits AA7 and AA8 were brought to further deny the claimant his right to participate and contest in the PTD branch election, as some of the conditions stated therein to enable anybody, including himself, to contest for any executive position of the branch as stipulated in the said notice are not in accordance with the PTD bylaws, but were merely formulated to completely shut out the claimant using the chairman and secretaries of various zones of the PTD branch of Nupeng. The defendant respondent, via their counter affidavit, stated that the claimant is the current national vice chairman of PTD branch of Nupeng. The third defendant is an eligible member of both the said branch, and the second defendant union is also qualified to contest for the exalted position of the national chairman of Petroleum Tankers Drivers branch of Nupeng. That it is not true that the defendant or anybody is planning to make the third defendant the national chairman or other members of the PTD executives by imposition without an election being conducted in accordance with the bylaws of the said branch. The further stated that it is true that the second defendant union has many branches which are based on the type of services rendered in the oil and gas industry throughout the country, said by the extant bylaw PTD branch of Nupeng, duly signed and dated on the 22nd of April 2022, that is Exhibit B. The National Executive Committee of PTD branch is constituted either by election or by consensus of members in accordance at the branch delegate conference held every 4 years and to be conducted by the National Secretariat of the Union and not by any electoral committee purportedly set up by the current national executive of the branch under the leadership of the first defendant. It is so that there is no gainsaying the fact that the claimant is an active member of the branch as the current national vice chairman of PTD branch of Nupeng and is free to vie for the position of the national chairman of the branch, but the defendants are not aware of his purported interest in contesting for the said position of the national chairman of the said branch, and nobody is stopping him or other interested person from contesting. That is not true that the claimant and some other members of the branch have ever protested at any time to the first defendant as well as to the second defendant about any illegal procedure being adopted and embarked upon by the first defendant to bring in any new executive at the end of his tenure as the national chairman, as no such purported illegal procedure was ever contemplated, adopted, nor embarked upon by the first defendant. He said these were baseless fabrications and mere figments of the imagination of the claimant who has no confidence and is scared of the supposed popularity and massive support that the third defendant appears to be enjoying from PTD branch members. That nobody wants nor intends to impose anybody on the said branch as its national chairman, and that both the claimant and the third defendant are from the same horizon of PTD branch and eligible to contest for the said position of the national chairman of the branch. That the said samples of union levy, receipts or tickets purportedly issued by PTD and the purported rig move branches respectively are concocted to mislead this honorable court. That Nupeng has no head office at Brimo Close, nor any other branch presently known as rig move haulage unit. The claimant applicant nominated a sole issue for determination, to wit, whether an order for interlocutory injunction is not imminent at this stage in view of the circumstance of this case. The defendant respondent adopted the sole issue formulated by the claimant applicant. Having gone through the claimant's applicant's application, his affidavits in support, together the exhibits therewith, and the written address, and the defendant respondent's counter affidavit, together the exhibits attached, and the written address, I am of the view formulated by the claimant applicant. Can you hear me? Can you hear me?
Yes, my lord, can hear you.
Okay. Having gone through the claimant's applicant's application, affidavit in support, together the exhibits therewith, and the written address, and the defendant respondent's counter affidavit, together with the exhibits attached and the written address, I am of the view that the issue formulated by the claimant applicant as adopted by the defendant respondent is apt and concise to determine the merit or otherwise of this application, and I adopt same in determining this application. It goes without saying that the burden of proof in an application for interlocutory injunction is entirely on the applicant, and he must discharge the burden in the affidavit in support of the application. This does not mean that the applicant has a legal duty to prove the merit of the case at the interlocutory stage. All that an applicant is expected to prove is that there are tribal issues or questions justifying the grant of the said application. I refer to the case of Morofula against Kwara State College of Technology and the case of Ezebilo against Chumuba, all citation provided. Having said this, the grant or refusal of this interlocutory application will be based on the affidavit in support of the application and the counter affidavit filed by the defendant's respondents. Premise on the prayer as shown on the application and the grounds upon which the application is brought, the chagrin of the claimant applicant is that there is a plan by the first defendant respondent to swear in the third defendant respondent or any other person as the national chairman of the petroleum tanker drivers branch of Nupen without conducting an election wherein the aspirants vying for the office will be elected. Additionally, from the wording of the interlocutory prayer of the claimant applicant, it is crystal clear that the claimant applicant also won the election for the nomination of the national executive of the petroleum tanker drivers branch of Nufeng to hold. Paragraphs 21 of the affidavit in support of the application also established this contention of the claimant applicant. Surprisingly, the claimant applicant yet again filed a further affidavit in addition to the earlier affidavit to support the application, to the effect that the second defendant respondent has published the electoral guideline for the National Executive of Petroleum Tanker Drivers Branch of Nupeng, but the claimant applicant is not comfortable with the electoral guideline for the National Executive of the Petroleum Tanker Drivers Branch of Nupeng. From exhibits AA7 and AA8, it is glaring that the second defendant respondent has fixed 30th day of June 2022 for the conduct of election for the National Executive of Petroleum Tanker Drivers, PDT branch of Nupeng. I suppose the further affidavit filed by the claimant applicant is counterproductive to the application of the claimant applicant. The claimant applicant is approbating and reprobating in his effort to establish the fact for the grant of this interlocutory injunction. The claimant applicant had earlier stated that the first and second defendant did not want to conduct the election for the National Executive of Petroleum Tanker Drivers Branch of Nupeng. The claimant applicant later turns 180 degrees to say that the second defendant respondent had issued the electoral guidelines for the conduct of the election of the National Executive of Petroleum Tanker Drivers Branch of Nupeng. Meanwhile, from the prayer for the interlocutory order, the claimant applicant won the first defendant respondent to conduct the election for the National Executive of Petroleum Tanker Drivers Branch of Nupeng. In the case of Corn Oil PLC against Solomon, reported in 2017, 3 NWLR, part 1551, 50 at page 8081, paragraph G to B, the Court of Appeal held, and I quote, "No party is allowed to approbate and reprobate on the same issue at the same time. He must be consistent." See also Suberu against the state. The situation here is akin to that in AG River State and AG Akwa Ibom State, where it was held that cannot rely on or take the benefits of contents of a document, which at the same time he turns around to question its legality. It is a doctrine of justice and equity that it is unjust and inequitable for a party to blow hot and cold at the same time, unquote. Although the claimant applicant objects to Exhibit AA7 and AA8 on the ground of non-compliance with the bylaw of PTD branch of Nupeng, and that the second defendant respondent can only play supervisory role in the conduct of election for the National Executive of Petroleum Tanker Drivers PTD branch of Nupeng. I suppose objection of the claimant applicant cannot be a basis to grant this interlocutory application. Granting this application on the basis of the legality or otherwise of Exhibit AA7 and AA8 will subject this court to deal with substantive suit at an interlocutory stage in the guise of an interlocutory application. And in the case of Iweka against SCOA Nigeria Limited, the Supreme Court cautioned that, and I quote, "This is because this court has advised in the case of Silvanus motion against Alhaji Mohammed Gambo that care should be taken when a court is hearing an interlocutory application to avoid making any observation in its ruling on that application which might appear to prejudge the main issue in the proceedings relative to the interlocutory application. This is as it should be for as Kokaje, as he then was stated in Kufeji against Kobe. The tendency is to avoid trying maintain question twice, to grant injunction only in clear cases. As further pointed out in the latter case, it is not necessary for the plaintiff or applicant to make out a complete case as will be required to do on merits, unquote. Another silent area that deserves the consideration of this court is that when the second defendant respondent released Exhibit AA7 and AA8, the claimant applicant did not make effort to obtain the nomination form to activate his intention to contest the election, but only alleged that the conditions contained in Exhibit AA7 or AA8 are a deliberate act of the defendants who will give the zonal chairman and secretary under the firm control of the defendant to nominate only persons selected by the defendants and refuse the nomination of persons like the applicant who is perceived an adversary of the defendant by filing this action. This is a mere speculation by the claimant applicant. I cannot see anywhere from this affidavit in support of the application suggesting that the act or conduct of the second defendant and even the first defendant respondent has infringed the right of the claimant applicant or damaged his interest in vying for the office of the National Executive of Petroleum Tanker Drivers branch of Nupeng. The Supreme Court, in the case of Union Beverages Limited against Pepsi Cola International Limited, at paragraphs BC held, and I quote, "I deal with the last point first. What required in this case before the application for interlocutory injunction could be granted was not only affidavit evidence that the alleged activities of the first, second, and third respondents were damaging the appellant and will prove fatal if not restrained. This is because the fact that act of the defendant is causing injury to the plaintiff is not sufficient for the purpose of determining whether an application for an interlocutory injunction should be granted. The application will not be granted if it is not shown that the alleged act of the defendant constitutes an infringement of a legally enforceable right of the plaintiff, unquote. Let me reiterate that the essence of grant of an injunction is to protect the existing legal right of a person from unlawful invasion by another. It is for the protection of a recognizable right. Hence, an injunction can be granted, though no pecuniary damages is proved, as long as the acts complained of will result in the infringing of the applicant's right. It is proper case for intervention by the grant of the injunction. See the cases of Okotoya against CBN, Obeya Memorial Hospital against AG Federation, and Akapo against Hakim Habib, all citation provided. The alleged interest of the claimant applicant is dicey, inasmuch it is not shown that he has been denied from participating in the election for the office of the National Executive of Petroleum Tanker Drivers branch of Nupeng. Hence, this application will fail. Interestingly, the defendant respondent have responded to the substantive suit. I would rather order for an accelerated hearing of the substantive suit, and if the claim of the claimant applicant succeed, this court can set aside any act purported to have been done by the defendant respondent. Let me mention that the legality of exhibits AA7 and AA8 is a matter to be determined during the substantive suit. I have not made any finding on it. This application is refused for lacking in merit, and it is hereby accordingly dismissed. And ruling is hereby entered accordingly, and I refuse to award any cost with regard to this application.
As the court pleases. Although we are most grateful for the well-considered ruling.
Yes. I cannot. Yes.
Can my lord hear me now?
Can you hear me?
Yeah, I can hear you.
Yes. So I will give this matter an accelerated hearing.
Okay.
So, and the registry will contact you and give you dates.
As the court
Yes,
pleases.
they will contact you and give you dates from Abuja, from Yanagwa. So I adjourn this matter to a later date to be communicated to all parties in this matter.
As the court pleases. We are most grateful, sir.
Thank you. Arise.
Hello.